Ladies and gentlemen, it's a great pleasure to welcome you to this new webinar on the European Data Protection Seal going global. So it will be a great opportunity to share with you the latest developments regarding the GDPR certification, and great honor also to welcome an outstanding list of panelists and experts to join us. Let me first introduce briefly the agenda. We will have a brief introduction on the GDPR certification, presentation of the two EDPB opinions, preparation in practice, how does it work to prepare the certification, then how does it work to certify under the European Data Protection Seal. Then we have the great pleasure and great honor to have Petra from Allianz will share her perspective as an applicant who has been certified, and then a few useful resources and a Q&A at the end. So in order to cover this topic, I have the great pleasure and great honor to welcome Alain Herrmann, Commissioner of the Commission Nationale de Protection des Données, so the Luxembourgish supervisory authorities, Petra Ziegler, who is part of the DPO head of Allianz, and she's senior privacy and AI trust expert, and Giovanni Francescutti, who is a global technical manager at DNV and leading the GDPR certification at the level of DNV, being the strategic view and perspective on it. So it's a great pleasure to welcome them all. Let me start by a few general information. The following webinar will be recorded and shared online for your information. You can ask questions through the Q&A feature of the webinar at any time. For us as speakers, or if you are giving the floor to speak as participants, when not speaking, please switch off your microphone. And another element which is important, that the content of the webinar is provided for information purpose and is not intended to be legally or contractually binding, except otherwise stated. The information provided by speaker and experts are provided in their personal capacity and do not necessarily represent the official position of their respective affiliation. Again, to ensure that we can have an open conversation discussion, that's important to remind this general information. Let me start by just introducing in a few words ECCP, the European Center for Certification and Privacy, which is leading and organizing the webinar. The center was established in the context of the European Research Program to support the bridge between the research community and the need on the market for compliance, data protection, and certification. Now, a brief introduction about the GDPR certification in general. So the key principles. So the certification in the GDPR is a very important mechanism. It is intended to enhance transparency, to enhance compliance with the GDPR, and also to allow the data subject or the different parties to have a quick and easy idea of the level of compliance with the GDPR, an indication that indeed that specific data processing activities is effectively complying with the different obligations of the GDPR. So it's about legal compliance. It's not about adequate management system. So it's really addressing the different legal obligations. It also entails some evolving requirements because the regulation may evolve in terms of jurisprudency, in terms of I see a raised hand. I don't know if someone wants to take the floor already. Marianica, let's see. Maybe you can communicate in the chat, Marianica. Then it's about evolving requirements because the implementation interpretation of the GDPR is also evolving over time thanks to the EDPB, which is clarifying the interpretation of the GDPR. And there is also the fact that it's a certification which addresses large diversity of data processing. Now, if you look at the text of the GDPR, it's quite interesting to notice that the certification is referenced or mentioned 73 times in the text of the GDPR. It's more than any other mechanism made available to companies, data controller, processors, or data different stakeholders. It's in particular very interesting to notice that certification is recognized, for instance, to demonstrate data protection by design and by default under Article 25. It's also recognized by the GDPR as a means to demonstrate adequacy of data controllers under Article 24. The same for adequacy of data processors obligation under Article 28. It's also a way to demonstrate adequacy of security obligations under Article 32. And it has also an impact on the administrative fines. And there is also another aspect that doesn't appear on the table, that certification is recognized as a mechanism for international data transfer, something we will be discussing in a few minutes under Article 46. Let me move to the next slide. And the reason why certification is so massively referenced into the GDPR more than other mechanisms, that when you compare the different mechanisms available, you will notice that certification has a characteristics. It's a mechanism which is based on effective control by independent third parties of the level of compliance. When you sign a contractual instrument like a SCC or any kind of contractual instrument, you have a formal commitment which can be binding and enforceable, but you don't have the guarantee that this commitment is effectively implemented. With certification, you have regular controls made by independent, impartial auditors to ensure that, again, the obligations are effectively implemented. So in terms of reliability, in terms of trustability, certification is particularly strong compared to other mechanisms. Now, a few words about Europrivacy. Europrivacy has been approved as European Data Protection Seal under Article 42 by EDPB, the European Data Protection Board, but also recognized by European accreditation already a few years ago. And then it took some time for the certification, once it was the criteria were approved, to get also a validation by European accreditation of the accreditation procedure and accreditation process. And that has been done, and it was completed a little bit more than a year ago. And since then, we started having the first European data protection seals delivered across Europe, and the first certification body is being accredited under Article 43 of the GDPR. What does it bring, and why are companies or different institutions interested in certification? There are a few key elements, key drivers. In particular, when we discuss with already certified companies, the companies which manage to get the data processing certified, there are a few elements. The first element is, of course, to check and prove compliance, because it's one thing to say, oh, I promise, I swear that I comply with the GDPR. It's a nice commitment, but it's not necessarily enough to ensure that, or to reduce the uncertainty. When you have, again, a certification body coming and delivering a certification, you reduce this uncertainty. You ensure a high level of trust, confident that indeed the entity which is presenting this seal is effectively complying with the GDPR for the target of evaluation. The second element is, of course, the ability to reduce the risks for all the parties, which is very important. Of course, that's a major aspect of any certification. Another element which is important, that certification indeed simplifies compliance, because under the GDPR, when you have, for instance, a data processor whose service is certified, you have less burden in terms of, for instance, due diligence to check and assess every obligations of the data processor. So it's a very interesting element and instrument to simplify compliance. That's a way to homogenize the way you will analyze and assess and document your regulatory compliance as a controller, as a processor. Then it's a way to build trust and reputation. It brings competitive advantage. It's also a source of value, compliance, and creation of revenues. Again, certification enables also for a company which is active on the market to perhaps gain more clients, to get more market shares. And it's a clear competitive advantage, in particular for data processors, when offering their services to data controllers. If their service is certified, it enables them to reduce substantially the risk for their client, for the data controllers. It's also a way to facilitate data sharing with controller, with processors, sub-processor, but also international data transfer, cross-border data sharing. It saves cost, particularly, as I mentioned, for all the obligations under Article 28 for the obligation of the controllers to monitor the compliance of the data processor. So it simplifies this effort. So it's also a source of cost saving. And there are other ways to save costs by homogenizing the management of the compliance and the documentation of the compliance. It's extendable to other regulations, but very importantly, it's legally recognized by all EU and EEA countries with legal effects and benefits under GDPR. That's something very important. For instance, you can have an ISO 27001 certification. That's great. That's very useful, very important, but it has no legal effect per se. A GDPR certification has legal effect because it is formally recognized under the GDPR as a mechanism to demonstrate compliance with impact, including in case of breach, in case to determine the level of the fine. So to summarize, GDPR certification and Europrivacy in particular have been designed on one hand to reduce risks, to protect and simplify compliance, but also to value compliance. So that's more or less, I would say, kind of summary of the value proposition and why this certification is particularly relevant for DPOs. Now, an important step has been achieved on April 15. EDPB approved 2 major opinions. So far, the certification was limited to EU and EEA located applicants. But now with these 2 new opinions, we have a completely new horizon which is opening for demonstrating and managing and simplifying compliance from a GDPR perspective. And for this, I would like to give the floor to Alain Herrmann to share his perspective and to explain to us why are these opinions important and what do they mean in practice.
Thank you, Sébastien. Can you just maybe move on one slide?
So we have the 2.
Yes, okay. So yes, as Sébastien already mentioned, until now, certifications under Article 42 of data processing from controllers and processors were only available for entities which are located in the EEA. And so now with this updated version of the certification criteria, the scope has been extended to include applicants subject to Article 3.2 of the GDPR. What does it mean? It means that entities which are outside of the EEA and which are subject to the GDPR will also be able to have their processing certified. So it means, for example, if I have a company in Brazil who is targeting European users, he's subject to the GDPR, he can have his processing certified. So one main element in those criteria, which has been assessed by the EDPB, is that there is an addition of a criterion which requires to assess potential conflict to third country law. So I will detail this a little bit more in a few seconds. And there have also been some criteria from the version adopted in 2022, which have been adjusted, refined, or clarified. So let me focus a little bit on this criterion to assess a third country law. So it means that before considering a certification audit, it requires a certification body to check that the applicant is able to demonstrate that the national law and practice of the third country does not hinder the applicant's compliance with the certification requirements. So if this is not the case, the certification process has to stop. So if the law is too, let's say, restrictive or does not respect Europeans' data protection laws principles, certification may not be possible. And so for the applicant, it means that the updated certification require the applicant to provide a report prepared by a legal expert assessing that the national law and practice of the third country do not prevent the fulfillment of the data protection obligations under the GDPR. Similarly, the assessment shall include that the national law of the third country does not impose restrictions on the data protection rights, which go behind what is necessary and proportionate in a democratic society to safeguard one of the objectives listed in Article 23.1 of the GDPR. So this article is about the possibility to restrict the exercise of rights under the GDPR. It also needs to check that the law of the third country is proportionate to the objective pursued and that it respects the essence of the right of data protection, that it provides for specific measure to safeguard data subject fundamental rights and interest. So now we also have in this situation the case where the applicant for the certification is in a country outside EEA benefiting from an adequacy decision. In that case, the compliance with this requirement may be demonstrated through a simplified report. So now we also have a second update of the certification criteria for this Europrivacy scheme, which is the Opinion 15/2026 that you see here on the screen and that you can also download on the EDPB website. So this version of the scheme, or this extension of the scheme, is intended to be used as a tool for transfer, and the certification issued according to the scheme could therefore be relied upon by data exporters in the meaning of Chapter 5 of the GDPR to transfer personal data to certified data importers not subject to the GDPR. So, in other words, it can be used under Article 46 of the GDPR to certify the transfer of data to third countries that are for entities that are not subject to the GDPR. So this means that transfer of personal data to the data importer in the third country can only take place after the same importer has been certified and has signed binding and enforceable commitments vis-à-vis the EEA data exporter to apply the appropriate safeguard envisaged in the certification criteria. Also, that those certification scheme as tool for transfer is a scheme meant to be applied on both a singular transfer, but also to a set on transfer when the latter are closely correlated. In this case, also in the context of using certification criteria for tool as a transfer, before considering a certification audit, it requires the certification body to check that the applicant is also able, like for the other one, to demonstrate that the third country laws and practice do not hinder compliance with the certification requirements. And if this is not the case, the certification process has to be stopped. So I will stop there. So now with all these possibilities on certification in the GDPR, so Article 42 for entities subject to Article 3.2, so companies outside EEA, and for certification as a tool for transfer, we have now available all possible certification tools that the GDPR the GDPR allows. So we have, let's say, I said, close the circle in this context. I think you can go on, Sébastien.
Thank you very much, Alain. And as Alain mentioned, so now we have, so far we had only the A option, which was available under GDPR. So only certification of entities subject to the GDPR and located in the EU or EEA. With these two new opinions, we are opening the two complementary cases. Case B, where the entity is directly subject to GDPR, despite not being in the EU, for instance, a company which is actively collecting data on the European market from European citizens. Even if it's located in a third country, it is still subject to GDPR because it is of its activities, because it's collecting data in Europe. And then you have entities which are not directly collecting data, but receiving data from another entity located in the subject to GDPR. In this case, that's what we name data importers. That is, are entities not subject to Article 3.2, but which can use a claim to use the certification under Article 46 to demonstrate their compliance and then to be recognized under Article 46 as an adequate mechanism for international data transfer, with one particular obligation that should be mentioned, that in order for the certification to be valid as a mechanism for international data transfer, it should be complemented by a contractual contractually binding instrument between the data importer and the data exporter. So there should be in place not only the certification, but in addition, in order to use the certification as a mechanism for transfer. So you can be certified, but in order to use it as a mechanism for international data transfer, you will need also to adopt a certain number of contractual obligations between the importer and the exporters for the tool to be valid, to be recognized under GDPR.
So I see there are some questions about the binding legal commitments which are required in the context of Article 46.
Perfect. So let's address it. Yes.
Certification. So just one word about this. Yes. So there are criteria that envisage that a contract between the data importer and the data exporter, including the relevant binding and national commitments, should be signed before any transfer takes place, and provides for a template of such a contract. And so in the criteria, you have a template of such a contract. And those content of these commitments, they are based on the guidelines on certification as a tool for transfer that the EDPB also published on its website.
Mm-hmm. Do you see any other question, Alain?
No, I just saw that.
Okay. And we can take to the audience. You can come back to some of the points later if you have questions coming to your mind. So, what are the benefits for non-European applicants to use GDPR certification? I think first element is a major reputational and competitive advantage. Having a company in a non-European countries, if it is addressing the European market to deliver its services, it's a major gain, major benefit, because it enables to protect the clients on the European market. As we mentioned under Article 28, if an entity, a company in Europe subject to the GDPR is sharing data, personal data with another company in third countries, the company in Europe remains highly liable for anything that would happen to this data in the third countries. So having service which is certified substantially reduce the risks for both parties. It's a very, very strong element which will certainly have a major role in decisions made by future data processing agreements. It protects and allows international data transfer from Europe. So there's really this notion of better protections and providing a lawful instrument or an instrument to support lawful international data transfer. It reduces legal risk for the applicant and its European B2B partners, as we mentioned. It is far more reliable and trustable than, for instance, SCCs or contractual instruments, because you have, again, regularly auditor coming and checking that indeed that the obligation is effectively implemented by the certified data processing. It simplifies compliance, one certification for all data exporters, for instance. And it must be taken into account in case of administrative fines, which is another element. Again, the idea of a certification is already to reduce the likelihood to have any breach of the regulation. But it may happen that even the best company doing all what it can may be subject to a data breach. There may be a hacker manages to sneak into the database or the server. And in this case, the judge has to take it as a factor when determining the administrative fine. So how does it work in practice for the preparation? There are a few elements. First of all, contrary to other certification, the GDPR certification, and I would say all regulatory compliance certification, focus on assessing the compliance with existing obligations. So it's very much about to comply with the GDPR. So a company which has done its homework to comply with the GDPR is in a good position to start the certification. Then you need to have a DPO and a record of data processing activities, even if you are small companies, and you need to document your compliance with the criteria. Then you focus on your priority target of evaluation. You identify what is the priority area of risk or the areas where you want, or the data processing where you really want to ensure full compliance and demonstrate compliance. So you can really select where you want to put your priorities. And then what you do, is once you comply with the obligation, the GDPR, the legal obligation that you have to comply with anyway, you start checking and documenting your compliance, which enables you already to reduce the risk, to identify potential non-compliance in terms of regulatory obligations. Then you certify, which is an opportunity to value your compliance, to communicate it to third parties, to build trust with third parties, and then you maintain and you enjoy. And what is very interesting, as I mentioned, this is something specific to regulatory compliance certification, that most of the effort is to be done anyway before any process of certification starts. Meaning that when you decide to start the certification, indeed, 90% of the effort of compliance in principle is already done because you are supposed to comply with the GDPR before starting the certification. Then what happens when documenting the compliance, you reduce the risks. And then when you certify, you have this process of value creation, turning your compliance effort into something you can value, something which becomes visible, which can be used by, for instance, sales and marketing teams, which can be used with the financial analysts, with investors or the different stakeholders. So it's very much about assessing, certifying, and at the end, taking advantage, enjoying the certification. And for these, we have a certain number of resources which are made available. First of all, ECCP is not delivering certification, is acting as a scheme owner, but is making the scheme available to trusted and qualified service providers, including certification bodies, the world leader in certification, world leader in law consultancy and consulting firms, and solution providers. And then these partners are here to support any organization, public or private organization, which wants to be certified. Then we have what we name a welcome pack, which is made available with a whole set of resources available for 3 years. We have a whole set of online resources, including the public website, the academy. Public website is available, I think, close to 20 languages. The academy is available already in 4 languages, and it's increasing. And the community website is the place where you find all the relevant documentation, including clear guidelines and books and resources to make the certification as efficient and user-friendly as possible. Now, let's give the floor to Giovanni to give you the perspective of how does it work from a certification body perspective, or what is the perspective of the certification body in this process. Giovanni, the floor is yours.
Thank you, Sébastien. I hope I'm audible. And I give you the perception of the certification body. Try to answer also some of the questions that I see raising into the chat. When you are ready, for the GDPR, and you think you are, ready to go for the certification, is the moment of the certification body. The certification body works is the one that is in the green bubble. The certification body is not delivering consultancy. The certification body, however, is the one that is helping also the company understanding exactly which are the best scopes, and target of evaluation that could be also delivered during the certification process. One thing that is important is that for the ones of you that are used to ISO certificates, ISO 27001, 27701, remember that the GDPR certification, the Europrivacy certification, is a data processing activity. So we are not certifying the whole company. We decide together with the company, which is the data processing activities, together with all the engagement with all the sub-processes in the company, that needs to be certified, but is focusing specifically on a data processing activity. This means that the job that is done by the certification body at the very beginning is also understanding exactly the target of evaluation, that is the application of the certification by the company. Then the activity starts. The audit is conducted usually in 2 stages. Stage 1, that is mainly a document review and a compliance review, and the stage 2, that is an initial assessment, that once we see that all the documentation is correct, is ready, is compliant with the requirements of the scheme, we move towards a logic where we are starting also interviewing people, looking how the process are working. For the ones that are asking also for the safeguard of security and accountability, we are looking also at the part related to physical security, IT security, to be sure that what is written into the paper is also delivered in a structured way, for the activities on field. And then we go for the certificate issuance. Certificate issuance that is done under the GDPR requirements. This means that the data protection authority at the end of the process is always informed whether this data processing activity is covering more than one geography. This means that under Article 58, we are informed, the data protection authority is informed, and all the involved data protection authorities are informed, and we issue the certificate. And then we go for an annual surveillance audit that is, covering, partially the scopes of the data processing activities in agreement also with the company, because the certificate has a 3-year validity. And after 3 years, the process starts with a sort of recertification. So it's partially, a complete audit that we do to give validity for another 3 years to the data processing, to the certificates and the certified data processing activity. Sébastien, if you can move to the next slide. Specifically for Europrivacy, the stage 1 that we are delivering is a document review. Mainly, we are auditing the documental part, so the qualification of the PO, that all the documents that are required are present. We verify that, how the company is working, the design of the processes, to be sure that everything that could be verified, during an activity done by a technical lead auditor and a lawyer, is compliant with the rules of the GDPR and the rules of the scheme of Europrivacy. The checklist, that we are using is the checklist of the scheme, so it's not something that is rocket science, but every single point is controlled, checked to be sure that we have a mutual understanding of what the company is doing, and eventually we are raising, the findings that the company need to solve before moving to the next stage. Sébastien, thank you. One important thing is the fact that whenever we are working, as a certification body, the certification is, we are always looking at the logic of the GDPR, but it is important also for data importers or, companies that are outside the European Union, but also in the European Union is the same. Depending on the target of evaluation, so the data processing activities that you are, putting or you want to put under certification, could be that local you have several local legislation that needs to be addressed, and the scope of this national obligation is also assessing the part of the local legislation to be sure that when we are delivering the certificate, we are not conflicting with local laws, and everything is done under, the correctness of the GDPR and the local laws that you need to respect. Consider that because Europrivacy is a scheme that is encompassing a lot of different industries, could be that we have different also local legislation that you need to take in consideration. Sébastien, thank you. The initial assessment, that is stage 2, that is the one that is moving at the end of the process of delivering the certificate, is the part that is mostly related, even if also in the document review, we move with some interviews and examinations. Over there is where we are, passing the majority of the time interviewing people, how the process are working. We are testing the environments. Could be that, for example, if we have to certify a website, the activity, the data processing activity that is, managing the contractual agreements subscribed and with a website, we are also, for example, testing how the website is working. So opening, a contract. We are doing some sample analysis on the databases. We are checking the IT security. We are checking and discussing with you also which are the security controls that are put in place to be sure to have a wider overview, not only of the documentation and the compliance, as is a legal compliance of all the documentation, but also how the process are working. The scope of this is giving, to the market a, rational, security that what we are certifying is managed also in a structural way. At the end of everything, you have the certificates. I put over there some example of public certificates that we delivered already, but just to show you how a data processing certificates looks like. Next slide, Sébastien, thank you. Just to give you an overview also of the major issue that we are finding as a certification body, usually is not so, the certification process is a classical certification process. could have some issues, the findings that we are finding during the audit. We give time to the company to correct those findings. What is important is engaging the certification bodies as soon as possible before starting the process to define exactly which is the target of evaluation. Because it's where we see a lot of confusion still in the companies, because there is a lot of confusion between management system and data processing activity. So the suggestion is, whenever you want to start with a certification, it's always better to start engaging also one or more certification bodies at the beginning of the process, just to be sure to focus exactly on what you need to achieve at the end of this process. Last slide by my side, if you move to the latest one, just to give you some understanding of what we received so far as a request for certification. Obviously, we have a lot of requests coming from Europe, a lot of requests are also coming from different countries, as you see are highlighted. This is something that is strictly related to us as a certification body. So to DNV, could be that the view of different certification body could be slightly different, but more or less is what discussing also with our colleagues of other CB we see on the market. And also what are the companies that are mainly asking for certification. As you see, the majority are IT services, because are the ones that wants to demonstrate to their controllers, usually are processor, what they're doing. But you see healthcare companies, financial companies, HR services, government institutions, e-commerce, telecommunications, energy and education. We are the mainly, industry, the main industry that are requiring in this moment the Europrivacy services. I cover all the topics that I wanted to cover during the seminar, as a certification body. If you have questions, we are here. Sébastien, floor, I give you back the floor.
Thank you very much, Giovanni. I think it was a very nice overview. And now let's see also the perspective of the end user, of the applicants. It's a great pleasure to give the floor to Petra, who has been one of the pioneers of the GDPR certification, the first insurance companies to be ever certified under the GDPR with the European Data Protection Seal. So Petra, it's a great pleasure to give you the floor.
Yeah, thank you very much. I hope you can hear me well.
We can.
Okay, good. So then let's have a look at Allianz. So as you know, Allianz is one of the leading insurance and financial services companies in the world. So we have about 120 million customers worldwide, and apparently, as our products are not feasible as such, we depend very largely on the data. And this is why we wanted to do such a certification. And before we decided to do a certification, we also chose to ask our customers if at all certifications for them would be relevant or not. And this is why, apart from the studies you could find on the market, which you can see in the upper part of the slide, we also did our own panel, particularly in Allianz in Germany, and asked our customers in an online panel how relevant certification or a data protection seal would be for them. And as you can see, most of them, at least over 80%, judged privacy certifications as relevant. So this is just for the customer view. And if you move to the next slide, so this was one of the main reasons why we decided to do such a certification. And this is this customer trust argument. As Sébastien mentioned in the beginning, it's kind of competitive advantage, but also to show our customers that if they buy an insurance product from Allianz, that their data is safe. So actually, it is even requested sometimes, for example, for large pension scheme programs in life insurance. Some of our brokers ask us if there are any certifications regarding privacy. So this is being used a little bit as a sales argument, and just ensures our customers that they can trust us with their data. On the other hand, of course, as you have elaborated already, it's the resilience perspective, the fact that Europrivacy is currently the only certification that is recognized by all European member states, and the fact that it demonstrates that our privacy framework is quite robust. Would you move to the next slide, please? Then we can look at some insights from what exactly we did. So we decided already in 2023 to do the Europrivacy certification, and we chose some of our operational entities, which is namely Allianz Austria and Allianz Italy, to certify some of their processes. And it was to these subsidiaries to define their processes themselves. So as you can see, they are a bit different, but largely they cover many of our, or most of our retail products because of this customer trust argument, and also some of our claims processes. So basically all the processes where there is a lot of direct customer contact. In parallel, we decided to certify also our global recruitment process, meaning every application that is coming in via our external career portal, which is careers@allianz.com, because we also not only wanted to ensure our customers, but also our applicant that their data is safe with us. So we certified these 7 targets of evaluations, and it took us more or less 1 year, I would say, for all the preparation, and the actual audit itself just took us about 6 months. And we are quite proud that we received then the certificates in February last year. To give you some concrete insights by the single certifications, please move to the next slide, where we can see the benefits. Sébastien, if you could just...
Yeah, it's already moved, but maybe there's a latency with the image.
Yeah, obviously. Okay, so now I can see it as well. Thank you. So here on the right side, you can see that particularly in Austria, they used it as a communication tool. So they had a press release about it, and they also communicated a lot on our certification in some broker portals, and they even printed it on some of the product information. So it really helps to do some targeted communication. Of course, we have it on all our websites, and we use it quite often in our promotional material. Of course, this is extremely important when we are talking about insurance lines of business where a lot of personal data and sensitive data is involved. So for us, for life and health insurance, it's quite important, but also for some accident insurance and so on, customers really appreciate it. On the other hand, you can even look it up when you go to allianz.com website or to our career portal. We have all the seals, and you can click on them, and then you can see exactly what is the target of the evaluation and what we have certified. To go a bit into the certification process, some lessons learned. I could only repeat what Giovanni already said regarding, you can move to the next slide, regarding the target of evaluation. Looking back, this has been one of the most important steps, but also one of the most difficult steps during at the very beginning. So if I could give some advice to future applicants, it is that you should carefully define your target of evaluation. So it should be as broad as possible, but as specific as necessary in order to have a process that is well defined, or several processes that are well defined. But it should also not be too complex. So it shouldn't be too big, the scope, because it could then include too heterogeneous processes. But on the other hand, it should be, as broad as possible to allow to communicate on a large scale. What was key for our preparation, of course, was all this document collection. In both cases, for Austria and Italy, it was always our DPOs who handled the actual audit. And for the legal part of the audit, it was quite easy, I have to say, because most of the legal documents were at hand. But the audit always also has a technical part, and for this, we, in our practical experience, also needed the support from some business owners like IT experts, our information security colleagues, and so on. So ensure that you have a central point of contact, but also involve, when necessary, other departments. During the audit, at least in our case, it was always in English. So for our countries, we used some AI tools to translate, but as we all know, it's not always the best quality. So calculate some time for also validating and approving your translations, and before giving them to the auditors. And we also had a couple of direct interviews with our certifiers and with the DPOs, and we saw that this always helped for clarification of some misunderstandings. So any explanation of processes, clarifications of minor things. So I would say, in summary, for each country, we had about 7 direct interviews or so, but sometimes it was just to clarify something. And also for future applicants, you should calculate sometimes if any issues are detected. Like as an example, we had in Austria, we had some privacy impact assessment that was not filled in very well. So you should also consider some time for potential remediation of these smaller issues. So just this could take another couple of weeks. But as you have seen, so overall it took us about 6 months, the actual audit, until we got the certification. And given all the topics, our 7 TOEs, I would say this was quite reasonable in the end. Yeah, so these are the practical lessons learned. Maybe in the next slide you have it a bit summarized. So for the time frame, I would say it took us 1 to 2 months for the scoping for this for the targets of evaluation. And as I said, this is one of the most important things you should do in the beginning. And the certification process then was about 6 months. So for the staffing, this is just a rough estimation, which I would share in the case for Austria, but of course this depends according to your chosen target of evaluation. Yeah, so this is it. I think for the surveillance audit and the certificate, it has already been mentioned by Giovanni, but overall, we are very proud that we are the first insurer worldwide who got this certificate, and we are also considering extending it to other countries, and will probably be doing this in the next year. So if you have any questions, then happy to answer them.
Thank you very much, Petra. I think it was very insightful and giving the first-hand experience of a pioneer in the certification. That's great, and we appreciate your trust in sharing this information. So thank you very much, Petra. And let me now then share a few tips and practical resources that you can leverage if you're interested to move ahead with the certification. I would say the first one is don't hesitate to contact us through the Europrivacy website. There are different ways, different options available to you. One, you can, for instance, contact us just to get maybe some clarification on the scheme. So ECCP will not deliver consulting, but we can clarify the process. We can give you information on how it works. We can also help you identifying or mobilizing resources from the ecosystem of the partner. You can also use the website to request offers from different partners. So you can select a country and say, oh, I'm interested in getting support for preparing the certification and or for being certified and or for documenting my compliance. And then once you use the form, it's shared with all the officially recognized partners of the ecosystem. So you can very quickly and easily get offers from different partners if you wish so. Then another option is to visit the Europrivacy Online Academy, which gives you a good overview, and you have the introductory course, which can give you a good overview. But so more interestingly, if you are interested to move ahead, you have the welcome packs, which gives you access to a whole set of online services, resources for 3 years, including accesses to the community website, to the introductory course for the academy, so the first publication fees and so on. Then another option is to use the Europrivacy criteria to document your compliance. You don't need necessarily to go up to the certification. Of course, you will not get the benefit of a certification, but you can just use the criteria to as an internal resource to document your compliance. And we know the cases of indeed the first certified applicant initially decided just to use the criteria to document the compliance internally. And then when he did it, he just realized that it would be very easy just to do the next steps and to move ahead with the certification. But you can use it without certification to reduce your risk, to document your compliance using criteria which have been approved by 30 national authorities, the 27 of the EU plus the 3 of the EEA, which have all reviewed each and every, I would say, comma and word of each and every criterion. You can also follow us on LinkedIn to get more updates. But one thing you can do also, in case you think, oh, you need still some time to reflect on or to get the budget for the certification, but one very low-hanging fruit that you can save risks and costs by requesting your service providers to be certified. And that's a very simple action you can trigger to request that those with which you are sharing personal data, because they are processing data on your behalf, are certified, because under Article 28, that will heavily reduce your risk, your legal risk, and it will also reduce the cost of monitoring all your service providers, where you need, if they are not certified, to do some due diligence, to control. That's at least what is expected from you under GDPR. And if you don't do it, you expose yourself to substantial liabilities and risk. It's also an opportunity for your service providers not to only request a demand to, or to get a demand to do something more for you, but also for them, it's so positive because it develops a competitive advantage for them. They will then have an advantage also on the market towards other clients they may have. And for these, we also develop something new, and that's a new support we have decided to provide, is to support companies who want to adapt their tendering or supply chain procedure, to help them and to provide them resources to adapt their procedure in order to privilege, or at least to take into account, the service providers which constitute a lower level of risk for them by being certified. So that's something, if you're interested, you are welcome to contact us, and we have dedicated resources which have been developed to help companies to align their procurement and tendering process. You have also a whole set of white paper, I mean the same white paper, but in different languages, which is available online. You can use the QR code or just go on Europrivacy website. You have also the possibility to discover testimonials from early adopters. So we see Philip Ratter, Cedric Nedelec from PricewaterhouseCoopers, and other DPOs, and you have quite a number of DPOs who are sharing their experience with the certification, their tips, lessons learned, how they would like, what they can share with you in terms of lessons learned and knowledge acquired through the process. We also have, as I mentioned, the possibility to follow us on LinkedIn and to share information we publish. And that's it. So I will close here for the presentation part to thank you all and then to open for the Q&A, the question that the audience may have. And we are pleased to address all of your questions.
Maybe just to tell, when we look at the questions, there are many of the questions linked to these binding and enforceable commitments. I just invite you to read the 2 EDPB opinions. You will get all the details there about those information. So the many questions will be answered there. I also saw a question about impact on the fine when you are certified. Well, it's mentioned in the GDPR that a data protection authority has to take into account the fact that a controller processor has a certification in case the link process is under investigation. So it can have a mitigating effect in case of certification. So it could reduce the fine. We don't yet have any, let's say, decisions on that context. I know that in France, the CNIL is currently investigating a company that has the certifications, but you have not yet the results. But on the other hand, it can also be an aggravating factor in case you misuse the certification. That's what the regulation says. I think there was also a question about if I'm under Article 3.2, can I also I don't know if it was to be certified under Article 46, but I think that if you are under Article 3.2, you cannot be under Article 46. So the answer would be no. Yeah. And I think there was also a general question about what's the differences between the, let's say, the ordinary Article 42 certification and Article 46 certifications. So the basis is more or less the same. It's just that the Article 46 takes into account specificities linked to the transfer and to the fact that the certified entity is in a third country. So there are some more, let's say, checks to implement, and it also introduces the notion of data exporter, data importer, and it also takes into account the transfer of the data. So meaning that you also need to do a transfer impact assessment in this situation.
So if you have any request to have more information, and if you think you would like, for instance, to have a dedicated webinar on the contractual clauses with the data importer, or on the difference between the different mechanisms under Article 46 between SCC, BCR, SCC certification, the differences, but also how you can synergize on the different mechanisms, let us know. We are pleased also to provide some dedicated content and also to organize a dedicated webinar. And again, don't hesitate to contact us if you need more tailored or specific information. We'll just go to the end. Yes, up. Here, so feel free to contact us through the website. You can also use the email address contact@europrivacy.com to contact us. And again, for everyone, we see a role as ECCP as team owner, but mainly also doing research and ensuring that the tools we make available to you are optimal. And we welcome any comment, any questions, and we have the chance to have DPOs or experts like Petra who are pleased also to brainstorm with us to see how we can improve it, to ensure that we can offer you the best experience possible, to demonstrate compliance and to make compliance really, and we mean it when we say we want to make compliance enjoyable. It's not a slogan, it's really something we consider as a fundamental objective for us, because if we make it enjoyable, we anticipate that privacy will not be anymore an issue, to be something normal and implemented by everyone. So we are really in these logics to take any suggestions, comments, ideas to improve it. So you're welcome to contact us and to share your experience, your suggestions, your criticism, to see how we can improve it. We welcome any element, any feedback, positive or negative. So thank you very much to all, and I wish you an excellent evening, and deep applause to our panelists for their participation. Thank you very much.